You're watching KCAL 9 News at noon.
It's one of our big stories today. Divorced parents with kids will not be able to easily move out of the state anymore. It's a change that will affect millions, and we'll have an expert to put the decision into some perspective for us. That's just ahead.
As we mentioned earlier, the California Supreme Court has made an important ruling concerning divorce and child custody. The court has now made it a little tougher for a parent with custody to move without the permission of the other parent.
Joined now by attorney Stephen Mindel. He's a family law specialist. Mr. Mindel, thanks for joining us. Let's start. What is the impact of this decision?
The primary impact of the LaMouche decision is going to be that the trial courts are going to have broader discretion in whether or not to grant a requesting parent's desires to move or the other parent's desires to keep their children in the city.
So how does it work now, and what change will there be?
Well, the primary situation is that the Supreme Court in the LaMouche decision upheld the current case law, which is the Burgess decision. That's the case that's been touted as being the case that allows the primary custodial parent to move. The Supreme Court decided to uphold that decision, but it expanded the trial court's discretion in deciding whether or not to grant a primary custodial parent's request to move away.
Give us a background on what the LaMouche case is.
The LaMouche case basically involves two parents who were having custodial problems in parenting their children. As a result of their custodial problems, the primary custodial parent decided that she wanted to move. She had her good reasons to move. She had remarried, he had remarried, and she decided to move to another state. When in the LaMouche case, what ended up happening was the court, because the non-custodial parent was able to make a showing that there would be detriment to his relationship with the children, the trial court then did a full analysis, which was thought not to be allowed. And then determined that it would be best for the children to remain with the father here in the state of California.
So if a custodial parent has to move, let's say for a job, the court would then have to weigh the impact on the child and the ability of the custodial parent to provide for these kids, no?
Actually, no. What the Supreme Court said in LaMouche is the following. In LaMouche, the court said that we are still going to uphold the decision in Burgess. It will not be necessary for a primary custodial parent to show necessity to move. But what happened and what was unique about the LaMouche situation is that these were two parents that did not get along. And so in essence, when the trial court found that there would be some detriment to the children, the trial court then felt that it was free, and it was upheld by the Supreme Court, to analyze whether or not the parent that was going to be allowed to move would continue frequent and continuing contact between the children and the remaining parent. In this particular set of facts and circumstances, the court believed the father that the mother would not encourage the children to have continuous visitation and contact with him, and granted his desire that the mother not leave. The big impact in this case is, as you said, is going to be with regard to child support, a parent having to move because of job necessities, and also difficulty in travel, because now since 9/11, putting 9, 10, 11-year-old children on airplanes is often difficult.
Okay. We'll watch these cases individually, I guess, and see how this all is impacted.
Thank you, Dave.
Thank you, Steve.